A warm welcome to all of you, and in particular, Professor Danae Azaria, who's visiting us from UCL, and she's a distinguished visiting scholar at CIL. We're very proud to have her. And I'm very proud to say also that today is actually the first of, there'll be others, but the very first of her book launch for this incredible project that Danae started how long ago now?
Almost 5 years ago, yeah.
It's been 5 years. Oh my! On state silence and international law. And I remember when I first learned that Danae had rightly been awarded this incredible 1 million euro, if I may say that,
And a
around
half.
there, 1.5 million euro, not dollar, euro award to do this, very important project. And now we see the first book, because I believe there will be more to come. I have known Danae for several years now. She's one of the leading scholars. And one thing that strikes me very much about Danae is just the breadth of her work. She won the Guggenheim Prize in Scholarship. And I remember this, her work she did on energy charter and energy and pipelines. And this was in 2015. But she's also the chairperson, together as the rapporteur, I believe, is our own Tara, on the ILA committee on pipelines and cables. And also, I didn't realize you're also on the committee concerning consent to military action.
Yes.
And international. She's one of the leading world experts on the International Law Commission. She's written quite a bit. So Danae is really a true generalist in international law, a very renowned scholar, and a good friend as well, a dear colleague. So I can't tell you how pleased we are to have her here at CIL in Singapore to speak about this remarkable topic, state silence, which I have to say something in the commission and those who deal with international lawmaking and state practice. What do you do with state silence? So, Danae, I don't want to take any more time for your speak, but may I say it really is fantastic to have you here. And I can call you to the podium, and the floor is yours.
So thank you very much. I'm delighted to be here, and it is an honor that this is the first event launching the book State Silence Across International Law, and we are doing this in Asia particularly, and of course at the Center for International Law in Singapore. The book State Silence Across International Law is one of the 25 research outputs that have come out already from the European Research Grant on state silence. And today I will present some general conclusions that come through this book. So, silence may speak. With this iconic statement in Pedra Branca, the International Court of Justice reaffirmed its established reasoning that state silence may have legal meaning in international law. In other words, state silence may manifest the intention of a state. The court did so in a case involving 19th century facts and a bilateral interstate interaction concerning territorial title. Now, this book concerns state silence interpretation in international lawmaking and international law evolution in modern international law. So its foundational idea is that owing to first the profound developments in the factual background, and second the major transformations in the framework of international law in the 20th and 21st centuries, the contexts in which state silence may be interpreted today have become complex, certainly more complex than in the 19th century, and they remain not well understood. So this book endeavors to understand these contexts better. Now, the United Nations International Law Commission, the ILC, completed 2 sets of draft conclusions addressing the legal significance of state silence in the process of custom identification and treaty interpretation in 2018, quite recently. So it usefully set out the circumstances that international courts and tribunals, including the ICJ, have developed for interpreting state silence as acceptance. The draft conclusions on custom identification include conclusion 10, paragraph 3, which reads, and allow me to quote it, "Failure to react over time to a practice may serve as evidence of acceptance as law, opinio juris, provided that states were in a position to react and the circumstances called for some reaction." Further, conclusion 10, paragraph 2 of the IOC's 2018 draft conclusions on subsequent agreements and practice in relation to the interpretation of treaties read as follows. Silence on the part of one or more parties may constitute acceptance of the subsequent practice when the circumstances call for some reaction. However, the IOC's conclusions and commentaries are abstract. No doubt they were intended to capture various scenarios. They also partly ignore modern realities. So in the following minutes, I will structure my talk as follows. First, I will discuss some of the modern realities of international law affairs, international affairs and international law, in which interpreters are called to interpret state silence today and the questions that these realities pose. Second, I will set out the contextual circumstances under which silence can have legal meaning, and particularly the meaning of acceptance. Third, I will share some conclusions that may be drawn from this book, which brings together 21 authors that are experts in different fields of international law, about the interpretation of silence in the context of modern international law, especially against the background of the rise of multilateralism of international organizations and international courts and tribunals. And fourth, finally, I will conclude with some recommendations for the interpreters of state silence. So starting with the modern realities in which silence is to be interpreted. Today, over 190 states exist, and each can make claims about the state and content of international law, thus calling for the potential reaction of other states. But while under international law sovereigns are equal, in reality, the economic, political, technological, and other capacities and characteristics of states differ considerably, and this may affect how outspoken or silent a state may be. So are these realities considered when determining whether or not silent states accept the claims of other states about the content of international law? With the rise of multilateralism since the last century, international organizations and other intergovernmental institutions have proliferated. They provide a permanent forum for communication between states. Do interstate communications entail that state silence may be taken to mean acceptance more easily than in areas where such fora are unavailable? Further, international law has shifted from bilateralism to the protection of community interests. So old international law, in quotation marks of course, was primarily based on a matrix of bilateral relations between states. But modern international law, alongside bilateral obligations, has also hierarchically superior norms, so jus cogens norms, such as the prohibition of genocide, of torture, of use of force, and erga omnes partes obligations exist. Are the structure and nature of obligations and norms relevant factors for the interpretation of silence in the process of these rules' evolution? Traditionally, also acquiescence in international law has been conceived in a bilateral interstate setting. But in modern international law, non-state actors, especially international courts and tribunals, but also expert treaty bodies, have proliferated and claim a place in the law's evolution. Some of these bodies have even argued openly that the silence of states vis-à-vis their own pronouncements entails acceptance as to the treaty's interpretation or custom identification. So can acquiescence be conceived in this way today? Now, this book's vision is across international law. So it's not state silence in international law. That will be the next book. This is about state silence across international law, because the vision of the book is across international law. Again, because the modern realities of international law are reflected in different fields. So this brings me to the circumstances under which state silence can have a legal meaning, and particularly the meaning of acceptance. As a default, state silence in and of itself, as a fact, does not have any legal meaning or any legal effect. Instead, under international law, state silence can be interpreted in its context. And more specifically, the following factors must be present for silence to mean acceptance. First, a state is silent in circumstances that call for the reaction of that state's positive, for that state's positive reaction, my apologies. But what are these circumstances? And I think that this is the biggest puzzle. The book argues that the circumstances that call for a state's reaction are assertive, clear, determinate, and consistently held claims about the status and content of international law, which affect the interests of the state that would later remain silent. The second circumstance that must be present is that the silent state is in a position to react. This threshold is twofold. First, the silent state must have actual or constructive knowledge of the circumstances that call for its reaction. And second, the position of that state to react is not otherwise impaired. And finally, third, reasonable time has passed from when the silent state is in a position to react. Now, this collective work shows that the interpretation of silence is a single combined operation where various factors, factual but also normative factors surrounding an instance of silence, are assessed together. All factors interact with each other. For instance, the clear, more determinate and consistent and widespread a claim or conduct of states is, the more an affected state is likely to be expected to react, the more likely it is that its constructive knowledge will be met, and a shorter period of time may be reasonable for the interpretation of an instance of silence as acceptance. Now, moving on to some conclusions that we may draw, well, we have actually drawn from this book in light of multilateralism, institutions, and international courts and tribunals. Now, first, the more parties a treaty has, the more states might be affected by a particular interpretation and may thus be expected to react. This may suggest that it is more likely that state silence can have the meaning of acceptance more easily in the context of multilateral treaties or general custom than in relation to bilateral treaties or special custom. In my view, that this proposition is unconvincing. The most treaty parties exist, the more chances exist that contradictory claims will be made by various treaty parties. And silence in response to contradictory claims cannot be interpreted as acceptance. Further, the constructive knowledge of more states would have to be established in relation to interpretation or modification of a multilateral treaty to be achieved, and more states would have to be in a position to react for silence to mean acceptance in that context of a multilateral treaty. And this is not so much an issue that is quantitative, it is also qualitative. The bigger the group of silent states, the more differences are likely to exist between them in terms of interests, economic, and other capacity. And this may be taken into account for determining whether constructive knowledge, for instance, is met. In contrast, when the treaty that is being interpreted or being alleged to be modified is bilateral, it can become clearer that the subsequent practice of one treaty party would affect the interests of the other treaty party, and that the silent state has actual or constructive knowledge. So one finding perhaps from this book is that silence may more easily mean acceptance in relation to bilateral treaties than in relation to the interpretation or modification of multilateral treaties. Now, second, the structure of obligations, namely whether they are owed indivisibly to all states or all states parties, or in bilateral pairs of states or states parties, and the interests protected by such obligations are also normative factors relevant for the interpretation of state silence in all processes of international lawmaking, from the making and identification of a rule to interpretation, modification, or even termination. Let's take, for instance, erga omnes or erga omnes partes obligations. These are owed to all states or states parties respectively. So according to the Articles on State Responsibility of 2001 of the International Law Commission, all states to whom an obligation erga omnes partes is owed, namely injured states or states other than the injured state, are entitled to invoke the responsibility of a state for breaching these obligations. Now, some may argue that we could draw an analogy between the approach of state responsibility and the approach that we ought to be taking in the law of acquiescence. Now, according to this reasoning, all states to whom erga omnes or erga omnes partes obligations are owed would be expected to react in the lawmaking process so as to prevent the change of the law. And this approach would make erga omnes or erga omnes partes obligations much more susceptible to change. Now, one of the conclusions drawn from this book is that transposing without any qualification the approach taken vis-a-vis standing to invoke responsibility into the law of acquiescence is dissonant, because these are two distinct legal constructs. Standing to invoke responsibility is discretionary. Instead, acquiescence is based on an expectation or an obligation, Obligenheit in German, the non-fulfillment of which does not entail a breach of a rule, but carries some legal consequences. And in this case, it would carry the consequence of acquiescence. My argument instead is that more contextual factors need to be present in order to identify which of all states to which the obligation or erga omnes are owed are then expected to react. For instance, let's take the prohibition of use of force, which is an erga omnes partes obligation under the UN Charter. If a legal debate of widespread and representative participation has developed in the UN General Assembly, which is a focal point for debates concerning these matters, then all members of the United Nations would be expected to react. Additionally, when erga omnes obligations are at the same time jus cogens norms, weighty evidence would be necessary in order to draw the inference that the international community of states as a whole accepts and recognizes such norms as peremptory and their modification. High level of clarity, determinacy, and consistency of claims would be required, and exceptional circumstances where the reaction of the international community of states is expected and where the notoriety of the legal claim is universal. Now, third, the machineries of international organizations and intergovernmental conferences, to the extent that they are public and transparent, may make state claims notorious to all parties, thus giving rise to their constructive knowledge. However, the particular workings of transparency and publicity in each institution and on each specific occasion ought to be carefully considered. It is possible, for instance, that different states may have constructive knowledge at different times. Now, let me give you an example again from the United Nations Charter. It is reasonable to argue that, as you well know, Article 51 of the UN Charter requires states using force to in self-defense and exercising the right under Article 51 to submit, to notify the UN Security Council about their uses of force. Now, it is reasonable to argue that all UN Security Council members have actual knowledge, or at least constructive knowledge, of letters, unilateral letters under Article 51 of the UN Charter. This is because of their particular position within the Security Council, which gives them easier access to information, as well as a particular non-legal duty to be informed of matters relevant to peace and security during their term as members of the Council. On the other hand, all other UN members may potentially have constructive knowledge of Article 51 reports, depending on more contextual factors. For instance, as soon as the UN Secretariat publishes an Article 51 letter in the repertoire of the practice of the Security Council, because this is the most systematic way through which states may become aware of the reports, constructive knowledge of a report under Article 51 would be met for a group of states which have particular connection to a particular incident of use of force, or which has particular capabilities or interest in the field of use of force. On the other hand, there are also still fields of international law that do not have the same level of intergovernmental fora evolved. So in those cases, there is no central forum where states may hold debates about the law in that field. An example is cyberspace law. State claims in those fields would become known to other states in a scattered and decentralized manner. In such contexts, arguing that a state has constructive knowledge is less reasonable, because it implies that states are expected to look for and find the individual claims of different states that have been communicated on different occasions through various means. And in these fields, longer periods of silence will be needed in order to establish that the silent state not only accepts, but even has constructive knowledge in the first place. Now, fourth, in some fields, such as international criminal law and international investment law, some courts and tribunals have very enthusiastically claimed that the silence of states in response to the pronouncements of these courts and tribunals in relation to the reasoning of these courts regarding the status of the law, means opinio juris, or acceptance of a particular interpretation of a treaty. The authors in this volume have taken the view that expecting that states should react to the reasoning of courts ignores the reality that states have limited resources, cannot follow regularly case law in particular fields and across various fields, and they cannot process these developments regularly. They cannot, as a result, formulate an internal position and thus object to potentially thousands of courts and tribunals decisions across an even larger number of such decisions, especially given how many courts and tribunals, permanent and ad hoc, exist today. Further, in my view, there is no need to even consider whether states accept the reasoning of courts and tribunals, because the legal value of the reasoning of courts and tribunals as a subsidiary means for determining rules of law does not depend on state consent. It strictly depends on the quality and strength and rigor of the reasoning, as the Commission has recently, in fact, stated, if I'm not mistaken, on teachings. Fifth, the legal process in which state silence is being interpreted may affect the weight of the factors that must exist so as to interpret silence as acceptance. For instance, it may be that more contextual factors must be present for the interpretation of silence as acceptance when assessing whether a treaty is being modified, as opposed to when assessing whether a treaty is being interpreted. Similarly, more evidence that state silence means acceptance may be necessary in order to widen an exception to a rule or for the extinction of an existing entitlement. These are some of the arguments that have been made in different areas of international law in relation to use of force, but also international humanitarian law in our book. Sixth, other objectives and key rules in a field may influence the interpretation of silence. For instance, to the extent that there is a presumption in favor of the stability of borders, of boundaries, weighty evidence will be required for silence to mean acquiescence in modifying a boundary agreement. Similarly, in relation to human rights treaties, a central objective is the non-regression of human rights. And this goal may explain why human rights courts have not interpreted the silence of states as acceptance of regressive interpretations of human rights treaties. Now, this brings me to three concluding recommendations to state silence interpreters. First, an assessment that a state is silent as a matter of fact in relation to a particular incident may be based on eclecticism of state practice. Now, this may be due to limitations in accessing material, but it may also be due to intentional neglect of the practice of some states or inaccuracy in the implementation of the inductive approach. However, presuming that a state or a group of states have been silent on a particular occasion may lead to the silencing of less powerful states. Thus, the interpreter of state silence should not presume that silence as a fact exists in particular instances, and should remind herself that an inductive approach is provisional until evidence to the contrary is furnished. Second, some authors have approached silence as a threat, and we see this consistently, I think, in the field, especially of the prohibition of use of force. Now, I believe that this approach to a discussion about silence in international law can be very counterproductive. Such understandings, first of all, may rest on the eye of the beholder. For instance, in the Temple Pref Vigiar case, Thailand may have understood acquiescence in a very negative light, given that it lost the temple because the court attributed the meaning of acquiescence to the silence of Thailand. But Cambodia may have seen the attribution of the same meaning to Thailand's silence as a real blessing because it contributed to a boundary confirmation by the ICJ that awarded the temple to Cambodia. Instead, this work's analysis across various fields of international law shows that the legal meaning of silence may maintain the legal status quo, for instance, by providing no evidence of opinion juris. It may contribute to the regressive development of international law, and it may lead to the progressive evolution of the law. For instance, in the field of prohibition of use of force, state silence in response to assertive legal claims by states using force might contribute to widening the exception of self-defense under Article 51 of the UN's Charter. It may thus narrow the prohibition of use of force. But in other fields, such as in international environmental law, silent consent to amendments adopted in a conference of parties, such as under CITES, facilitates the adaptation of the law to new scientific knowledge so as to protect more species. And third, in light of the prevalence of state silence as the default state conduct, and I think we should never forget that, silence is the default state conduct. The exception is making a statement or taking action. And in light also of the various meanings, legal meanings and effects that silence may have in various fields, the solution that we as international lawyers can offer to states is not simply to go around and encourage governments to speak up at all times about their views regarding a particular area or to protest against the position of other states. State action, including expressing one's views, requires positive effort with allocation of resources to an internal process of very complex deliberation between multiple domestic governmental departments or other state organs. Additionally, no state could reasonably be expected to express its views about any activity in all fields governed by international law today. Further, states are involved in both political and legal communication and processes, and silence plays a role in both of these processes. So encouraging states to express their views constantly ignores the diplomatic reality and the real costs and limitations that most states, both developing states and developed states, face in terms of resources. It also ignores the fact that silence may be culture or even gender contingent, which may influence whether a particular state representative would speak up or remain silent in particular instances. Instead, the legal interpretation of silence must be better understood, conceptualized, and taught. And this approach will help governments understand when they ought to speak out and what language, in fact, to use when they do so, lest they will be taken to accept. It will also help, I think, minimize the risk of ignoring the interests of the less powerful states, which may rely on silence as a powerful political tool. I hope that this new book may contribute to this direction. Thank you very much.